Smith. Would you raise your right hand? Do you swear from testimony about to give shall be truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Yes, this is Assistant General Counsel. I wanted to do so again. And before you is a proposed settlement agreement in case number 2012-05273, Department of Health versus Harold Edward Smith, MD. The settlement agreement is the Department's proposed resolution of a 2-count administrative complaint alleging a respondent committed medical malpractice and inappropriately prescribed a controlled substance. Respondent failed to meet the prevailing standard of care regarding the treatment of an inpatient at a mental health hospital. Respondent failed to closely monitor the patient's symptoms and failed to adjust the patient's controlled substance medication accordingly. In addition, respondent did not consult or order appropriate consultations with specialists regarding the patient's complicated symptoms and drug-seeking behavior. Of note, the department would like to correct errors contained in the board memorandum. The respondent actually has 2 final orders against his license, the DOH 030920 SNQA. The memo only indicates 1 final order, which is DOH 070193 SNQA. In addition, the respondent has had prior discipline involving an inappropriate prescribing count. The terms negotiated between the 2 parties include a reprimand, a $10,000 fine, cost not to exceed $6,747.01 for the UF prescribing controlled drug course or board-approved equivalent course, and a CME in risk management. Considerations in support of this settlement agreement are that these counts represent the respondent's first medical malpractice violation and second inappropriate prescribing violation. The department believes that prescribing controlled drugs course will educate the respondent about appropriate prescribing and address his prescribing issues. The risk management CME will provide the respondent with education on the consequences affecting medical licensure in the state of Florida due to incidents of medical malpractice. The fine is within the disciplinary guidelines. As such, the department recommends that the board adopt the signed settlement agreement as a reasonable and appropriate settlement of this case.
Thank you. Now the respondent may proceed.
Red light on?
Yes, sir.
Okay, very well. Good morning still. My name is Vance Dawson. I am here together with my colleague Juan Ruiz. We represent Dr. Harold Smith. We represent him not only with respect to the Department of Health complaint, but also with respect to a medical negligence claim brought on behalf of Ms. Tomlinson's estate by Mr. McLeod, who's situated here immediately to my right. The doctor and I have gone over the proposed settlement agreement with the Department of Health attorney, who incidentally has been very helpful, very kind to us, and we have agreed to the terms, and I don't intend to defend Dr. Smith's standard of care here, despite a strong desire to do so. I do want the board to understand that Dr. Smith is very contrite with respect to what happened. Obviously, the loss of Ms. Tomlinson was an extreme loss. Yes, ma'am.
You have to use initials for any patient records.
I apologize for that. Sure. I'm not so sure I know. I'll just call her Mrs. T. The loss of Mrs. T. And as such, I don't want to get argumentative either with regard to the standard of care nor causation issues. I recognize the latter, which don't play a role with respect to this proceeding. And I'd like to perhaps reserve any further comment depending upon what Mr. McLeod says, if I could reserve a little bit of time in that regard. But otherwise, the doctor is here and available to field any questions that you all might have of him.
Now before that, I'd like to hear from the counsel representing the victim.
Sure, I'm Mac McLeod, an attorney from St. Augustine, and do represent, as Mr. Dawson said, the estate of AT or Mrs. T, if we'll agree to call her that. Unlike Mr. Dawson, I was not aware of nor counseled with respect, not that I had to be, with respect to any settlement agreement in this case. I, like him, I have had conversations with Mr. Orso, who's been very forthcoming to me. We sent the information off to the department that I think engendered the complaint, and also sent some additional information, which I believe just now has been recognized by the department. Let me begin by saying, as a representative of this person who's now deceased in her estate, it's not lost on us concepts of potential redemption and second chance. That said, and as counsel said as he began this is the third, at least the third time this individual has been before this board, and every time it involves drugs. The 2 times prior to this time, it apparently involved his own inappropriate conduct with respect to prescriptive medications. We do disagree with the concept that he hasn't been before this board for a malpractice event, albeit I understand the statutory or the designation of that. In truth, when he was originally before this board regarding acts in the year 2000 and leading to the order in 2003, among the allegations there were that he inappropriately prescribed to family members. I believe his defense of that at the time was, no, it just said family members. I was actually doing it to myself. I don't think inappropriate prescriptions to third parties is anything less than malpractice. So I think this is at least the second time that's occurred. I think the most disturbing issue for us is not just the issues of malpractice here, and that is, I will tell you that having discovered the case and being involved in it, and this is not the place to argue the malpractice case in the civil context, only in the administrative context. But the allegations by the department in this case are exactly the evidence in this case. That's exactly what occurred. I appreciate counsel indicating Dr. Smith is contrite. He may be today, he hasn't been prior to this time. And there are some telling admissions that he made in his testimony in this case, one of which is that while taking this woman as a psychiatrist, taking her on pain medication from 10 milligrams essentially of Lortab a day up to 90 milligrams a day of OxyContin without ever conducting a physical examination and without ever contacting her pain physician, the medical examiner ultimately found that she died of the intoxication from those drugs. That hasn't been, contrition is about redemption and admitting things. That hasn't occurred in this case. Regardless of that, what we're also concerned about in this matter is this individual was there for the purpose of psychiatric help, mental and emotional problems. She was being monitored and managed by a pain physician. Notwithstanding the allegations in this case by Dr. Smith that she complained of, quote, severe pain, her pain allegations while at this hospital have been flowed. They were being managed by someone else outside the hospital. Regardless of that, we don't think that she was ever truly seen or understood or managed by this physician, and the records seem to bear out that wasn't the case. But notwithstanding the allegations back and forth as to what occurred, the context has to be understood of who this individual is. And as Mr. Warso and the department now know, this individual had his DEA license revoked, yet was prescribing medicine through some deal with Central Florida Behavioral Hospital. He had his license revoked permanently by the Department of Justice DEA in a public record that indicates he's had his license revoked or lost by 4 other states before Florida, and that it was because of drugs, that he is admitted to being a crack cocaine addict, an opioid addict, an alcoholic, all leading to him coming to Florida. And since he's been in Florida, your own records indicate that as late as 2006, these issues occurred. The DEA public record, the order of the DEA, also indicates that he's continued to do these things and he presents a risk to the public. No one knows that better than the widow of Mrs. T. And in that circumstance, he should not be practicing medicine in the state. The DEA order says that, and it's important because the defenses in this case have to be believed to be accepted by this board, as to that it was just, I didn't get it, I didn't see it, I did see her. Because the DEA and the DOJ and all of these applications indicate that he constantly is untruthful in both applications and statements of his own behavior. In fact, the very wording in the final order of the DEA with respect to his history and his applications indicate this individual exhibits a, quote, shocking level of dishonesty. And that's not discontinued in this case. He still says that he saw this person and kind of picks and chooses from the record. Yet what's clear is Ms. Tomlinson goes in, and 4 to 5 days before she dies, she's starting to sleep anywhere from 13 to 17 hours a day, during which time Dr. Smith says, oh, he was seeing her, and during which time he's increasing her medication, such that she ultimately dies of the intoxication from that. It can't be believed what he's saying, and to come before the board and say, I made a mistake, or I wasn't getting appropriate reporting, may or may not be true, but the great amount of evidence demonstrates this individual couldn't find the truth with a flashlight, and never has been able to, and has found that to be the case many, many times. He says he hasn't had any opioid problems since 2000, yet this board, this department, and this board has evidence that as late as 2005 that was occurring, and the DEA order says as late as 2011 he was still relapsed. So my point in being here today is this gains me no truck and no traction whatsoever in the civil case. But what's important, and I think the reason why we're probably required in the circumstances of civil law to make these complaints known to this board and to the department, is for the purpose of the safety of practice. And the federal government, the Department of Justice and the DEA has found that he's unsafe to practice. It's in an order. And to indicate now, if his statement is, well, I'm just going to teach at the University of Florida, fine, you don't need a medical license for that. My client requests that in circumstances of this case and of the incredibly shocking history of this individual, who's you put on your programs, your PRNs in the past, and he flunked 3 separate times, that in those circumstances, this individual should not hold a license to practice, much less any ability to ever prescribe medicine again. And I ask that you please reconsider for revocation in the circumstances.
Well, thank you. Board members, any questions? You have an opportunity to rebut.
Yes, sir, if I may, just a brief rebuttal. We all know that the subject matter with regard to this complaint is not a lot of what Mr. McLeod was talking about. We understand that the issue with regard to this case is what Dr. Smith did or did not do in the December 2011 timeframe. I'm looking at a Department of Health document here authored by Shayla Washington, which indicated that dated June 24, 2011, indicating that Dr. Smith, it says, the Board of Medicine Probation Committee held a meeting and held that you are ineligible to practice. You fulfilled your requirements with respect to PRN. I don't think it's really appropriate, candidly, to talk about Dr. Smith's prior dependency upon drugs, because clearly he has been clean and has complied with all of the department's requests since June of 2011. I'm looking right here at the letters dated June 2011, but he began his compliance in terms of the PRN in 2005. So we're talking about issues and items, or at least Mr. McLeod is, that are nearly a decade old, certainly considered remote in most courts of law. That having been said, what I'd like to talk to you a little bit about is the amount of medication that was prescribed, because if we're going to talk about the discovery in the civil case, I did take the expert's deposition of Mr. McLeod, and who happens to be a psychiatrist, and the psychiatrist states that he co-manages patients who are prescribed as much, if not more, medication than Ms. Tomlinson was receiving by Dr. Smith. The point being that this is not an excessive dosage. What I'd really like to talk to you, though, about is this issue about the hospital itself, because there are records in the Central Florida Behavioral Hospital chart which indicate that Ms. T, Ms. T was asleep in her bed, and yet there's a psychologist who is authoring notes indicating that Ms. T is actively engaged in psychotherapy. So the suggestion that she was asleep this entire time is contrary to the medical records of Central Florida Behavioral Hospital, and for Mr. McLeod to rely on that when he knows that he has brought a claim against them as well seems a little disingenuous to me. So the records upon which Mr. McLeod relies in terms of using it as a sword is the same that he used as a shield to advance his claim against Central Florida Behavioral Hospital. I've had this case looked at by experts, both with respect to the issue of standard of care and causation. I have board-certified experts in the field of psychiatry, and I have pharmacologists suggesting that this amount of medication, as was prescribed, was not too much. It was not an amount that would cause a 0.25 milligrams per liter amount of oxycodone in the patient's blood serum levels, and ultimately, Dr. Smith is here to answer any questions that you might have.
Okay, Paul,
I have a question for the department. We have the final order in here for the one case. Can we get some information on the second prior discipline case? Because we have here, I guess, the one from, it began in 2005 and ultimately an order was entered in 2007 where there was suspension among other things that were included.
That's correct. That what you have in your materials right now is the second order, final order. That was actually related to the first order. The second order is based on his non-compliance with the first order.
Dr. Zachariah, listening to the deliberations and in view of all of that, I would actually move to reject the settlement agreement.
Second.
Thank you. And I would actually...
Any discussion, suggestion? Hearing that, all in favor say aye. Aye. Any opposed, motion carries. New motion.
If I may, Dr. Zachariah, thank you, and for the board members, I would recommend the same settlement agreement, except instead of a UF drug course, I would actually add a UF cares evaluation. And I would also add a suspension until the evaluation has been completed by UF cares. Then we get to look and see how we can comply with the recommendations.
Second. Is there any further discussion? Hearing that, all in favor say aye.
Let me clarify, again, I'm without Nancy, so, same terms, but instead of the UF drug course,
If I may, it's a reprimand, $10,000 fine, costs as stated. UF cares evaluation, forget the risk management course, and a suspension until the UF cares evaluation is complete, and then we get to see what their recommendations are.
and
And then we reserve
to
the
run
right.
pro-judicial terms.
Correct. That's it.
So basically the same terms, but you get rid of the risk management course, require a UF cares evaluation, and reserve jurisdiction.
And a suspension until the UF cares is complete, and we reserve jurisdiction to basically put on additional.
The U.S. drug course, is that in or out?
That's out.
Out.
It's
So-
the U.S.
so all the CMEs out.
Correct, all the CMEs.
Is there any further discussion on the motion? Hearing that, all in favor say aye.
Aye.
Any opposed? Motion carries. Pass.
Costs are currently $5,512.79.
Thank you. I think you have 7 days to, is that accept or not? Okay, next case, tab 23, I'm sorry, tab 23.